Good morning, ladies and gentlemen. My name is Brian Tarquino, and now I'm going to talking about the case Codling against Paglia. The first one is the facts. Number one fact is on August in 1977, in a clear day and dry day, Cristiano Paglia was driving his automobile on Route 144 in the south of Albany. In that moment, suddenly the car crosses the solid double line into the northbound line of traffic and crashed head-on with an automobile owned by Maria Codling and being driven by her husband. Paglia had purchased his 97 Chrysler Newport custom sedan about 4 months before the accident and had driven in just over 4,000 miles. At the time of the accident, he was traveling at the speed 45 to 15 miles per hour when suddenly and then unexplained his vehicle started to drive over the double solid line into the northern line. There was evidence that Paglia neither blew his horn nor applied his brakes, although short skid marks were observed. So after the facts, I want to talk about the problem. The problem is, do drivers have liability with the drivers of another car and their passengers when the crash was caused by a mechanical fails? In this case, the court talking about the torts. The first tort is the under a doctrine of strict product liability. The manufacturer of a defective product is liable to any person injured or damaged if the fact was a substantial factor in bringing about his injury or damage. This one, we can talking about three. The first one is that at the time of the occurrence the product is being used for the purpose and in manner normally intended. The second one is that if the person injured or damaged is himself the user of the product, he will not, by the exercise of reasonable care, have both discovered the defects and perceived its danger. And three, that by the exercise of reasonable care, the person injured or damaged will not otherwise have averted his injury or damage. The tort number two. Contributive fault of the plaintiff is a defense to an action for strict product liability, and the charge that is the not constitutes reversible error or mistakes. The contributive fault of a plaintiff could be found in a use of the product for other than its normally intended purpose and other than its manner normally intended. And the tort number three. Contributory fault could be found in the failure to exercise such reasonable cares as would have disclosed the defect and the danger attribute this. Thank you so much. I'm finished.